Yo, give me your phone.
No, bro. Wait, don't you already have your own phone?
I said give me your phone.
No,
Leo.
let's not do that.
Give me your phone, Leo.
Oh.
Give me your phone, Leo. Give me your shoes, Leo.
Help! I'd like to report a crime. Police, help!
Hey, stop! Come here. Drop those items. Get on your knees with your hands on your head. Get on your knees. Get up.
Oh. Before we begin the interrogation, I'll read you your Fifth Amendment rights. You have the right to remain silent. Anything you say can be used against you in a court of law. You have the right to legal counsel. If you cannot afford an attorney, one will be provided for you. Do you understand the rights I have just read to you?
Yes.
With these rights in mind, do you wish to speak to me?
No, I wish to speak to a lawyer.
Okay.
Go.
We will now summarize the scene. So the previous scene was to demonstrate a potential criminal police interaction, as well as the beginning of the interrogation process.
As you saw, Jacob was read his Miranda rights prior to interrogation, which is meant to prevent self-incrimination. Before 1966, states did not have to tell a suspect their rights, but in 1966, in a landmark court case, Miranda versus Arizona, it incorporated the Fifth Amendment to the states.
I also opted to have a legal counsel, which is a Sixth Amendment right. If I am accused of a crime, then I am allowed to have a lawyer in the room during my interrogation, and if I cannot afford one, then the state will provide me with one. Similarly to the Fifth Amendment, before 1963, the states did not have to provide an attorney to suspects that could not afford one. But in 1963, in another landmark court case, Gideon v. Wainwright, incorporated the Sixth Amendment to the states. Both cases were decided during the era of the Warren Court, led by Chief Justice Earl Warren.
Stop! Stop! Stop!
In the previous scene, you saw me, the police officer, stop and frisk Jacob simply because I believed that he was going to commit a crime and that he was presently armed and dangerous.
Ben's ability to do this was because of another landmark case, Terry v. Ohio. This case set the precedent, or guidelines, that the Fourth Amendment allows police officers to stop a suspect if the officer has reasonable suspicion of a crime.
An officer, however, may not be suspicious of a suspect simply because they wish, as this would be an unreasonable search and seizure, and this would violate the Fourth Amendment.